It was the turning point of recovering the name of sherry, of our wine. And of course, that headline was a very positive one indeed 50 years ago. So this evening we have some very distinguished guest speakers with us to take part in this roundtable discussion. We don't want it to be boring. We don't want you to think that this is a long, serious, drawn-out debate. We want to make it interesting, and I think the historical viewpoint is extremely important. And the experts we have with us this evening were directly involved in the landmark ruling. Directly to our introductions, Mr. David Sills, who is a solicitor for the Supreme Court of England and Wales. He studied at University College in London, and in 1966 he finished his law finals and was designated as an article clerk, which is a very distinguished position, and he was assistant to the solicitor Robert Keeling, and he had also defended cases concerning champagne earlier in his career. And he, of course, was also involved in the Perelada case as well. He is directly involved in the Sherry case, which, as you all know, took place in 1966. He was a solicitor then, and then he is now a partner at the law firm Monnier, Williams and Keeling, and he has throughout his career been involved in different aspects of intellectual property, copyright, design right, but most especially he is well known in his wine cases concerning champagne and sherry, and in the protection of designations of origins. He is accompanied by Mr. Charles Goemer, who is also a very distinguished expert. He's Director of Economic and Legal Affairs and member of the Executive Leadership Board at the committee, the Interprofessional Committee of Vin de Champagne, which, as you probably all know, is the equivalent of our Sherry Wine Council, that is the trade association that represents the collective interests of champagne producers and growers. And he has been in charge for many years in managing the interests of champagne wine growers and producers, and is now Director of Economic and Legal Affairs. And since 2003, he has been a leader in managing a worldwide campaign in protecting champagne PDO, and is also representing the Champagne Committee in different areas around the world. He also is involved in consulting and advising the International Organization of Vine and Wine. He is a national expert in Paris in that international organization, and a member of the International Wine Law Association. And by the way, he is also a reserve in the Gendarmerie, French Gendarmerie, which is also a very worthy cause that is, indeed. And so I would also like to, of course, involve in this discussion the former director of FEDER Jerez, the federation that brings together all of the sherry wine growers and producers. And of course, he was the director of FEDER Jerez at the time of the case ruling. And of course, at the time, his duties were shared between London and Jerez. He worked in London, and as well as studying business at Deusto, has worked in Bilbao in the north of Spain, has also been involved in various positions in the city in London, and then he, of course, was also on the board of Williams and Humbert. In 1964, he was Director General of Harvey's, and in 1966 went back to London to take over the section of sherry wines with Banco Bilbao. So here in Jerez, he came back in 1968 and was for many years member of the board of Feder Jerez, as well as its director. So he has very long-standing experience in sherry, in all of the different aspects of defending our identity in sherry wine, both in law, in commerce, and in the marketing. And he has also has the Orange Nassau Medal of Honor from Holland, and is also a distinguished witness of this sherry case. Before giving the floor to each of our distinguished speakers, I would just like to give you a very brief introduction, if I may, just to, shall we say, set the stage about what we are really dealing with, is the importance of defending our identity and the guarantee of our origin. And that is really what the case was all about. We know that sherry was always a, shall we say, a world traveler. It's always been present in different parts of the world. It was never a wine that was limited to this region. There was always a wine that was going to different markets. We wanted to make sure that that this is first and foremost recognized. It's a wine that comes from a very specific region, but with its transport always arrives in good conditions to far away points around the world. Historically, it has a very interesting, actually a riveting history to it, because its history is very closely linked to Africa, to the north of Africa, to different parts around the Mediterranean, the Phoenicians, the voyages across the Atlantic to the Americas. So sherry wines have a fascinating history, and of course the British influence cannot be denied. We know that within its history, perhaps England is perhaps at the very forefront of its history because of many different events that happened in the past. Many historians are fascinated and love to discuss where the word sherry came from, when the term was actually coined, when wine actually began to be called sherry. We know that it's just it's not just the transliteration of the name of our city into English, but it has lots of other historical facets to it. It's enormously popular in the UK, as you know. So there is that close link between Spain and, well, actually Jerez, the city of Jerez, and England from the late 16th, 17th century onwards. Many English families actually settled in this region, and there are many cases, I'm sure you are all very well aware of cases of British families that settled here in Jerez and actually became wine-growing families. The saga really covers centuries of British connections with sherry. And so there are lots of cultural, historical, social intricacies that bring sherry really, really very close to Britain. And perhaps that's one of the reasons this case actually arose over the centuries. Because it was not only due to the importing of sherry wines, but actually the fact that sherry wine has conferred so many different characteristics to it. You know, it's been exported. You know, its exports have grown. It's grown 10 to 15% every century. It's grown exponentially. And as you know, there are many bodegas. There are lots of wine cellars that actually bottle their wines in the UK. So it's not only a matter of protecting the origin of our product, but it's also protecting the region, the country, which is altogether shapes the identity of sherry. And perhaps here in Jerez, we feel it even closer to our heart. We have to feel it closer to our heart because sherry is Jerez. Jerez is sherry. That is the name of our city, the name of our region where this wine is made, that produces sherry, is really part of our identity. And so it comes as no surprise that we want to safeguard it. We want to protect it. So as a result, the word sherry means so many different things to us. For those of us who are from Jerez, it is a word. Sherry is a word that we want to protect, that we feel a need to protect, because it's a product that, although we export it, really comes from our origin. So the intellectual property aspects, as you know, is nothing new. It's been around for a very long time, and although perhaps if you look in a more historical context, it may seem something that has come into vogue more recently. You know, there's been agreements in 1883, there was a convention in Paris that came up with the protection of patents and property, industrial property rights and brands. Then there were other agreements and conventions passed in Bern and in Madrid in 1886 and 1891, respectively, to protect literary and artistic works of art, other protection of brands, copyrights, designs, but really as a legal term, as a legal format, it was not applied to wine until much more recently in Spain. And so, as you know, in the 20th century is really when the designation of origin, or the appellation, or as we call it in Spanish, the denominación de origen, is really something of the past century, of the 20th century. So that was really the first step towards constituting a legal protection. But it's not a solution to the problem by any means whatsoever, because we're talking about something that was just in its very beginnings. So what was the situation when other appellations were created beyond our borders? Well, it had to do with other wine-producing regions around the world that were ahead of us, other places in the world, in France, in Europe, in Latin America, and other places where these products were exported. But of course, our wines were already present in many of those markets, in many of the countries of the Commonwealth at that time. In 1935, this was the situation. This is the world map in 1935, and you can see that those two green lines don't have anything to do with climate change here. It has to do with the areas of the world where there are a good number of countries which were part of the Commonwealth and that were already producing their own, shall we say, versions of wine, their own kinds of champagne-type wines, port-type wines, sherry-type wines. And so different types of wines were being created and produced, and they were being classified as such. And in 1935, we didn't have the wherewithal at the time to protect our sherries. So, of course, these imitations of sherry were proliferating around the world, and they were using the word sherry to define their wine. We felt it was unfair, but at the time it was legal. It could be done. They could call these wines sherry. So what were these products at the time? Who were making these, shall we say, imitation sherries? Well, here you have some labels on the screen. You can see some of the bottles of the wines that were being produced at the time. So in general, we're talking about, well, an unfortunate circumstance in which most of these products were unfortunately of a very low quality. The amount of alcoholic content was something that they boasted of. They were also very sweet. They were also overly sweet. They were also used oftentimes in cooking, in culinary applications, and they were usually bottled in large format. So we're not talking about quality here. We're talking about origin. Where were these products made? So even if they were of a good quality, we would continue to want to protect the name sherry just because they were not made in this region, in the Jerez region. So we're talking about the complexity of a problem that has been around for a very long time. This is not something that happened very recently. The use and the customs, that common law recognizes that this actually was happening for hundreds, shall we say, even nearly hundreds of years. So we're not talking about something that came up very recently. So we oftentimes don't look at the importance that these products don't have to fall into demise. They can continue to be produced, of course they can, but they have to be called something differently. They have to find another name. So we had to look. We were considering that at the time in the 1950s. The sherry importers, the Sherry Producers Association, were looking at the fact that the name had to be protected, just as port wine and champagne were protecting their labels, their names. So how could we go forward in protecting our name on an international scenario? Well, there are different formula, but I would say basically there are two alternatives that we were confronted with. There's the multilateral treaty, or there is the bilateral treaty format. The multilateral alternative is a bit more difficult about registering a brand, a trademark, a name, a denomination, or a designation of origin. In a multilateral way is much more, it's far more complicated, it's far more complex. So really the strategy that historically we have found more successful or perhaps more satisfactory is the bilateral agreement alternative. So this is, again, going back to the world map, the Mappa Mundi. Here are some of the achievements or the success stories that we have been able to attain in bilateral negotiations around the world. You can see in different colors, and I think this is quite telling because it shows us that protecting our origin can be a negotiating point on a bilateral level. We can enter into negotiations with different countries about passing legislation protecting our name and our origin. We know that this is not possible in every country, but we can see in Northern Europe, in the UK, in the United States, Canada, we have had success in bilateral negotiations, thanks largely to efforts that the EU has also made. We have agreements in South Africa, in Australia, in Canada, in many different countries. And of course, they all have their different peculiarities, but there is an agreement in place. But there are other places, such as the United States, which is perhaps is unfinished business, and in New Zealand and in Latin American countries such as Mexico, Argentina, Chile. These are perhaps some of the countries where we have quite a lot yet to do. So we have a lot of challenges facing us in the future. Needless to say, we're going to continue our efforts, and we are going to try to not only look for full compliance with agreements, but also closing agreements with countries where they still do not exist. We want to, of course, rely upon the EU and our national authorities to back us on these initiatives so that in places like New Zealand, Mexico, or the Mercosur countries, Ukraine or Russia, they have an association they have also a production of a product there called Cepex that is a bit worrying, but we need to look what is being done in the Ukraine, in Crimea. These are places where we're quite concerned about, closing agreements in somewhat of a near future. So of course we mustn't overlook that we have made enormous achievements historically, but we do have increasingly very important challenges ahead of us. Perhaps one of our major markets, one of the most important markets for us, is indeed the United States. And there are so many imitation sherries in the United States. Lots of them And this is $100 million market. And so we're talking about 1.3 million boxes of 9-liter bottles. These are being marketed in California and New York at a third of the price of authentic sherry. And really, they leave a lot to be desired in terms of quality. Shall we be frank about it? Well, obviously, this is one of our pressing challenges. So the EU did have a wine accord on wine with the United States in 2006. This wine accord was theoretically about the semi-generic wines. It had to do with the European designation of origins and the appellations that were protected in Europe. However, that wine accord had 17 exceptions to it, and that's what they call the semi-generics. And we, I think, all will agree that a lot of these 17s, semi-generics, include some of our historical labels, such as Champagne, Port, Sherry, Chablis. All of these fall under what they call the semi-generic. And we have a problem with those names being used in the United States because the law in the United States hasn't fully closed this wine accord. It has not reached the level. There was a door left open for a second phase of negotiations, which never occurred. And more recently, it seems that there was a little bit of a breath of fresh air blowing through the window, but the window was slammed shut once again with Donald Trump coming into office, and so it's not a very promising scenario. That is, reactivating that agreement looks like it's going to be very tough going, very dismal when we know that the counterparts that we're going to be negotiating with are not going to be open to our vindication. So we are still hopeful that sometime in the future we will be able to take up those negotiations once again and perhaps exert as much pressure as we can to find ways to negotiate with the United States. We have to find some way, perhaps Mr. Goemar and Mr. Sills can give us their viewpoint about what might be the best strategy in terms of going forward with protecting wine origins. That it's not an anti-American campaign. There has to be some way that we can talk to the administration, the U.S. administration, about going forward, and that it's a good thing. That it's a good thing that consumers have the most accurate information about what they are drinking, about where it is made, and it will affect the way we can promote our products on equal footing with other imitations of Chablis, port wine, Beaujolais, or others. And we know that there are there were 8, and now there are 23 European wine-growing regions, and these are high-quality wine-growing regions that are all defending the protection of their designation of origin. A protected PDO is important for them not only as producers, but in terms of protecting the consumer, so that the consumer knows exactly what he or she is drinking. So I'm sure our distinguished guests tonight will have lots to say about this, and this was just my way of introducing the subject. And hopefully I haven't gone on too long in setting the stage for tonight's discussion, and I would be more than pleased to hear what my colleagues have to say.
Inviting me tonight, it's a great pleasure, it's a great honor, and I think it's really fabulous to celebrate this anniversary, which is a key element in the global GI protection worldwide. And I usually say that there exists a strong brotherhood in the wine sector, and this has even a stronger meaning between Champagne and Jerez. Since I learned this morning that we share many things in common. I knew already a couple, but I learned this morning that chalk, that important rainfalls are very common points between Champagne and Jerez. But we are also historical wines that led to a very long tradition, as César mentioned for Jerez, and I think that the same occurs to Champagne. We are both, all wines are both symbols of our respective countries. We are famous worldwide, and last but not least, we are facing significant problems of protection in a number of countries, in particular in the United States. First, we could say that facing counterfeits is good news. Indeed, counterfeiters usually are attracted by added value. And so when you decide to create some value, then you should be prepared to protect yourself. And as I expressed this afternoon to a journalist, IP protection is, in a certain way, the other side of the coin of promotion. So it's quite natural that successful wines like Jerez and Champagne do face some problems. And as César mentioned, these problems are long-standing problems. The very first decision that created the protection of Champagne in France dates back to 1843, at a date when even the trademark law barely existed. And that was a consequence of the long-standing efforts of the Champenois to promote their wines, to promote their name, that slowly made Champagne becoming a symbol of the most well-known sparkling wines. From that time on, Champenois traders understood that one, the value of their name, two, the importance of protecting together their collective assets would be their core mission for the time being. The only thing that they did not realize at that time is that they should not so much invest on protecting the name in France, but they should also be concerned about what happened in other countries. Indeed, they were, as sherry producers, they were wide exporters. They exported wines in many different countries, and slowly the name Champagne started to turn from being a tribute to the big brother Champagne to becoming a semi-generic. And suddenly, in the 1950s, Champenois discovered that they were facing a big problem. At that time, indeed, they realized that in most of the countries in the world, Champagne had become a generic term to designate sparkling wines. So from that period, they started a titanic mission, which was trying to recover the exclusive use of the name Champagne worldwide. César already described some of the tools that were possibly used to achieve this task. The multilateral and bilateral negotiations, and as César mentioned, we, or the European Commission, first France and then the European Commission, obtained some significant successes that allowed Champagne to be finally protected in Chile, Vietnam, South Africa, Australia, and a number of other countries. Then we also started industry-to-industry negotiations that led us to obtain protection in Japan and in Brazil. We also litigated in a number of countries. As we are celebrating the 50th anniversary of the British sherry case tonight. We could have done the same 7 years ago in Champagne, since we obtained the very first decision to protect Champagne against a so-called Spanish champagne in 1960 in Great Britain. That decision led then to a very important decision in New Zealand in 1990, where an Australian champagne was considered as misusing the designation of origin champagne. And finally, we were able to register the geographical indication champagne in a number of countries. And I would like to mention two very important countries, which are India and China. So nowadays, the situation is much greener, and we have obtained a significant and strong protection in most of the countries in the world. As you can see, after 70 years of efforts, there remains just a very few number of countries, but two of them are significant on the map, the United States and Russia. Finally, we still have a problem in Argentina, and a problem which will be solved in 10 years from now in Vietnam. So we do have some legal tools in many countries. We have some tools to allow us to protect ourselves, but having legal tools is not sufficient. You have to use it. And in fact, the fact that we got a title or a tool to protect ourselves doesn't mean that we have that we do not face any more problems. On the contrary, I should mention that the country where we face the most important number of counterfeits is France. This was the very first country where champagne was protected more than 170 years ago. But as I mentioned, counterfeiters are looking for added value, but they also try to make as much money as possible with the lowest possible risks. And so France is the first champagne market in the world, and France is also the country where most of the brands are sold. And so being a counterfeiter in a market where more than 5,000 different brands are used is easier than being a counterfeiter in, let's say, Laos, where only 2 brands are on the market. So we now have some tools to protect ourselves against counterfeits. These are the 2 bottles on the left-hand side behind me. We also have made some efforts to try to avoid generics and semi-generic terms. And as César and I mentioned, we still have some work to do. But we are also facing a very special situation in Champagne. Our name is misappropriated to designate many types of goods and services which are absolutely not connected to Champagne. This is a consequence of the wide notoriety, wide reputation of our name. Of course, we could consider that a shoe maker that uses champagne to designate a shoe is not a problem. We could consider that champagne cigars or champagne cigarettes are not a problem. We could consider that a perfume sold by Yves Saint Laurent under the brand Champagne is not a problem. That said, what makes our names very exclusive is the fact that it is only used to designate our products, and what makes it a very valuable name is the fact that we have created a kind of Pavlov effect with the consumer. When I say champagne, you should only have one concept in mind, the sparkling wine coming from a specific region of France that you hope to drink when you want to celebrate something. Maybe we have some champagne tonight. So finally, we have slowly started to improve the scheme of protection of champagne. And we came to the conclusion that we faced a very heterogeneous situation from one country to another. And so we have created a strategy to try to improve this protection, which is trying to explore the borders step by step. And when you explore the borders, one of the problems is sometimes you cross the border, and when you cross the border, you are defeated, which unfortunately happens from time to time. That said, we still have a lot of challenges in front of us. One of the first challenge is the fact that many foodstuff producers are trying to attract our reputation by adding a small portion of champagne in their products and using the name as an attractive tool for the consumers. Of course, this is a very hard topic, and this is something we talked together this afternoon with César. This is a hard topic because we are facing two different legitimate objectives. First one is in providing a fair information to the consumer. There is champagne in the product. The consumer might be able to know that. And the second objective is to protect an IP, an intellectual property right, which is the designation of origin champagne. So we obtained a number of decisions, and I wanted to mention this because last Thursday, the Attorney General of the ECJ, the European Court of Justice, just provided us a very interesting opinion on a case which concerned the sorbet, the ice cream behind me, which contained a wide important amount of champagne. But the general attorney considered that the prominence of the name champagne on the product, plus the different graphic elements that attracted the attention of the consumers, were probably misappropriations of the name champagne. Then there is another issue, very tough issue. This is protection of our name on the internet. This is a tough issue because with the internet we have duplicated the problems that we face. And the two examples that I just picked up are interesting in that respect. On the left-hand side, you have a call girl bar in Thailand, the genuine one, that you can only take advantage of if you go there. But down the slide, you've got the same thing, but on the internet, and so suddenly you can provide your services worldwide. And the second, so this is for the benefits of the company. Then the drawback for us is that with a formal shop or service provider, you know where you go. You can sue this company and finally obtain a successful decision. With internet services, technology goes so quickly that before you have been able to deliver a case, then the company has moved to another country, or the website has been renamed, and you have to restart all the proceedings. And so this is a nightmare, and we are facing a situation where we do not have we do not have the tools that we would need to protect ourselves. The second problem is fighting against counterfeits is an hard task. We have to make investigations to identify the counterfeiters. We have to seize the goods and to fight against those. That said, internet has made the problem even wider. Every day you have dozens and dozens of new counterfeits, And once again, before you have started to litigate, the goods have been sold or are sold on another page, and this is a never-ending story. On the internet, you've got a naming system, which was originally a very limited number of extensions, .es for Spain, .com, .edu, and a few others. And in 2012, ICANN, the regulatory board of the internet, decided to widely open to new domain extensions, domain strings. One of the domains, the extension that was proposed was .wine. At that time, we considered with the wine industry that we had to fight against this situation. Otherwise, we would have an open window for counterfeiters and misappropriations of our names. And so, while internet is usually a very open process, which doesn't really like this kind of opportunities and initiatives, we were able to obtain a very interesting agreement with a company that applied to the .wine in order to obtain a very specific protection to our names, this decision or this agreement, that was signed with the wine sector was a very interesting thing, and allowed us to demonstrate that we deserved. I mean, the wine sector deserved a very specific protection. One of the elements that was important for the owner of .wine was the fact that we did not only want to avoid misappropriations, but we are, before everything else, we are economic actors, and if we could trust that .wine was a fair string, then we would use it. And you have here two examples of how we are using .wine. Finally, because I'm already too long, I wanted to underline the fact that we are, of course, important businesses, but we are strong because we are working together. Cesar mentioned the fact that we are facing a very important, very tough problem in the United States. We discovered that if we continue to be ugly Europeans that wanted to get rid of uses of the name champagne, sherry, and port by legitimate US companies, we would be defeated forever. And so instead of always fighting against the United States, we have decided to create a brotherhood, a coalition of wine regions, initially American and European wine regions, that were following the same goal, protecting our names, because those names are for us are some assets, but are also some ways to describe our wines for the consumers. And having created this coalition allowed us to give a new and totally new message to the US administration. Instead of being the ugly Europeans, we were suddenly becoming a coalition of wine regions, including Americans, which were not asking to change the American system, but only to provide a fair protection of our names. One of the things I think that might be the path for future success is the fact that instead of asking the US to change their system. We are asking the the United States to protect their consumers, to give them accurate information, and to protect intellectual property right holders. This is still a long time to go. Maybe Donald Trump will not let us reopen the bilateral agreements, but we strongly believe that we are on the right way, and we have to continue to follow it all together. Thank you very much.
Again, we are here to commemorate, to remember what happened in 1967, and we're going to look at the very beginnings of where it all started for sherry and what happened after that turning point. And we're going to see after the famous sherry case. I'm going to give the floor to Mr. Breton. We've been working for many, many years in the Jerez region. Even after the case sentence, the ruling was made public. We've been working for the past 20 years. I was working in England in the 1960s. I was working in the city, and I didn't know much about it. I didn't know at the time how important it would be to be part of that. And I didn't, of course, fathom being here 50 years after the court ruling and commemorating that event. In the 1960s in London, wine was becoming increasingly popular in society, especially amongst young people who really didn't have a lot of experience in wine consumption. They had sherry parties at the time. So a bottle of sherry was opened in family gatherings and friends, with friends for parties, and thousands of bottles were sold then, and the prices of wine at the time were actually high for the time, and so most of the wine then that was used in these sherry parties and these sherry gatherings wasn't really sherry from Jerez, but it fit the bill. It fit the bill for the time. So we should say the British sherry that was being consumed then, British sherry, was really the label that was being consumed then. If we look at the ruling itself, I think Judge Cross said that in 1967 there were excise taxes of 42 million 42 millions of liters of British sherry were being consumed. But the imports to the UK that were being bottled there didn't surpass 30 million bottles, and that included a large amount of sherry that was being bottled by Williams and Humbert and Harvey's. And in November of 1965, I joined the Williams and Humbert board. That was a personal decision of my own at the time, and due to family circumstances, I decided to join Williams and Humbert, and I will forever be grateful for many of the opportunities I was given to protect sherry, and I was able to know a lot of the people that were involved in the sherry case, Domecq, the Gonzalez and Bias, and of course Judge Cross had 36 pages in 1967 in the beginning of the court case. And it was a pretty long, drawn-out case, and we all know that they were talking about the use of the name sherry and the imitating of the sherry type wine. Of course, the world was quite different then, and of course, the prices were different, the levels of consumption were quite different, and of course now the wide range of products that are available today were not available then. But if we look at the amount of diversification and the amount of consumption that has risen in that time, and even all of the legal protection measures that have been taken over these past 50 years, it's astonishing to see how important this ruling actually was. Its significance, it was absolutely amazing, because it was a landmark ruling in terms of defending PDO, protected designation of origin or denomination of origin as it is called here in Spain, and of course the use of these semi-generic names. And I'm going to look at the ruling itself of British Sherry. As you know, in the UK, the use of the name British Sherry was going to be able to be used as a semi-generic name because it was going to be admitted as an exception, because after many years there was an authorization for these sherry type wines to include where they were produced. So in Ireland and the UK could retain those wines in the domestic market using that name, that compound name, British Sherry or Cyprus Sherry, or they could use those as compound names but not use the name Sherry alone. And that is part of the importance of that ruling. And as you know, it was then broadened in 1975. And so it has advanced. Of course, at the time, Spain was not a member of the EEC, and it would only become a formal member state in the 1980s. So in the organization of wine, and wine has also had an important role in the application and the enforcement of this ruling. But when negotiations were going on for Spain to join the EEC, the European Economic Community, Jerez was very involved in the topic of discussion in protecting sherry as a denomination of origin and be acknowledged and protected as a member state. And we tried to get the Spanish authorities to back us, but there wasn't much success. And there was a multi-sectorial meeting in 1986 in Madrid, and I did attend that meeting, and there was a proposal given to then Prime Minister Felipe González, and I remember him saying that he wasn't going to pursue the matter. Don't ask. So in becoming a member state of the EEC, Spain, in one of the articles, Article 127, I believe he said, in the UK and Ireland, the compound names Irish Sherry, British Sherry, and Cyprus Sherry could be used. Those three compounds were the only three left. And then in 1995, and the article again went back to that and considered this measure and decided not to modify it, even though the Commission had put forward a recommendation that all of the parties involved, all of the stakeholders of the sherry wine industry had advised to a modification. So it seems that there really are no other English sherry, Cyprus sherry, those other compound names fall off the list, and just those last three remain. So again, there was some achievement made. There was some advances and some progress made, but again, this was just a turning point. This was not the end of our struggle, but it was, as I say, a landmark ruling, and it was the beginning of something new and a renewed effort. And in 1999, there was a package of tax measures taken, and the United Kingdom had to approve a bilateral agreement with the Kingdom of Spain in 1992, and this was on January 1, 1992. And at that time, the use of the compound names of reference would cease to be used. Cyprus Sherry, British Sherry, English Sherry, and Spain subscribed this this package of measures, and this was key to the development of the measures in the EU, and it required the unanimity of all of the member states. So we conditioned our signature to that, of this package of fiscal measures, to the formal commitment of the United Kingdom to determine, as of 1996, the acceptance of these conditions, and which was complied with and had to do with one of the great differentiating factors here of fiscal incentives that are provided in terms of this. And so perhaps the energetic and the merit of all of this, the energetic support of the Spanish government really had to do with the economist, Don Rafael Colombo, who devoted much of his lifetime to working towards the protection of the Sherry Wine Council. And that was the end of the British sherry, the use of British sherry as a companion after 30 years. So that was 30 years after the initial ruling, opening the discussion for further comment. As you say, when we're talking about many of the different agents, stakeholders, actors, call them what you like, there are so many different stakeholders involved. And so that's why it's so important to have government institutions and to have the authorities on your side so that they can protect all of those stakeholders, because let us not overlook the fact that we're talking about a denomination of origin or a designation of origin is a public it's a public title that is endowed, that is given to these wine growers and the products that they make.
My task is to look back at what your forebears in Jerez achieved 50 years ago. And when it was first suggested that the 50th anniversary of the Sherry case deserved a celebration, I imagined that we could just have a good party, one of the many things that you Jerezanos are good at. I had not realized that it would involve formal recognition at a pleno of the Consejo Regulador and a round table in this splendid bodega San Ginés. And even more shocking to me, I didn't realize I'd be pushed forward as a so-called guest of honor. Thank you for that, but of course, the honor is not mine. The honor belongs to those giants of the past who were the prime movers in establishing the case and obtaining that judgment 50 years ago, none of whom, sadly, can be here with us this evening, as none survive. I was a lowly, young, newly qualified lawyer just starting out, and lucky enough to be an assistant to those giants, and I'm here simply because 50 years on, I'm a lone survivor. So you get me. And I love the Sherry case because it was my first experience, my first taste of the line of major cases which have provided me with my entire career. And as Cesar has said, the judgment 50 years ago was not the end of the problem for Sherry. It was just the first step towards the proper protection of your name, which was being abused in England. I've lived with the judgment and tried to develop it, to build on it for all my professional life, and I had the great good fortune to be able to stand on the shoulders of those giants who created it, and I've played a part in developing their original idea into the major force of intellectual property it's since become. So I would like to pay tribute to the memory of those giants whom we are here to honor, and I must first, of course, mention our good friends from Champagne, who first established the new principle of law upon which the Sherry case was founded. Their team of English lawyers, who were my colleagues, had invented the then wholly new concept of a collective right to protect a geographic name. It was, of course, wholly new only for the English. As Cesar has said, the Europeans had been developing the concept of appellation d'origine contrôlée for decades, but English law entirely lacked any recognition, let alone effective protection or control. So when the Champenois succeeded in protecting their name Champagne under English law, the Jerezanos quickly recognized that they could do the same for Sherry. So it is that perception and drive of those Sherry interests from so long ago which must be honored tonight for recognizing and pursuing the opportunity to protect against the threat to Sherry's good name. And 4 Jerez firms were named in the case, representing all the sherry houses. The 4 named were González Bias, Pedro Domecq, Williams and Humbert, and Mackenzie & Co. Your president, Don Beltran, is particularly familiar with the main drivers of the case from that time. His father, Beltran Domecq, was then in charge of Williams and Humbert, one of the named. His uncles included Charles Williams of Williams and Humbert, as well as Jose Ignacio Domecq at Pedro Domecq. The González Bias representatives were Manuel Maria González Gordon, Tio Manolo, and his son Mauricio Sr. And Mackenzie & Co. were represented by Ian Mackenzie in London and Ramiro Fernandez Gao, whose own bodega in Jerez had close ties with and later became part of Mackenzie, and he was energetic and prominent in organizing the Jerez interests. He was sadly taken from us far too early, shortly after the case concluded. And also involved was Don Beltran's predecessor as president of the Consejo at the time of the case, Salvador Ruiz Verdejo, who had been president since 1939. And he made his first visit to London to appear as a witness at the trial of the case 50 years ago. And you see a large... Most of those appear there behind me. These are the people we need to honor, the drivers and promoters of an interesting case based not merely on the principle of protecting the name, but also on a clear-sighted appreciation of the commercial value of doing so, and with sufficient resources and determination to pursue it. The trial hearing in London started in February '67 and ran for 29 days of argument and oral evidence from 51 witnesses. The judge was Sir Geoffrey Cross, later Lord Cross of Chelsea, a Lord Justice. And it's his words delivered on the 31st of July 1967 which ring down the ages to define and protect sherry as meaning only the wine of antiquity and renown coming from Jerez. It was he who recognized that the earlier Champagne case brought by the predecessors of our honored guest, Charles Gomer, had, and this is a quote, uncovered a piece of common law which had hitherto escaped notice. This is the way English lawyers talk about new law. And that piece of newly discovered English common law established the principle that applied as much to sherry as it had done to champagne. And it was 50 years ago, that next Monday, that he uttered those words which enshrined the protection in English law. And I emphasize English law, not European law, not EU regulation, but English common law. So it will continue to be just as effective after Brexit. Yeah. The 1967 Sherry judgment was not simple and straightforward, as the previous speakers have said. I've mentioned that it was the first and major step on the long path. It clearly established sherry as a protected name for wine from Jerez, and that was clear, but it also permitted the exceptions that Juan Luis has mentioned, justified by their long use without objection, in particular British sherry. And this produced a logical and linguistic absurdity that something called British sherry was not sherry and could not be called sherry, but it could be called British sherry. So it left us with two tasks which occupied much of the next 30 years, and it would take Juan Luis 30 years to explain it to you. The first was the routine policing of the trade to ensure that the name sherry on its own was reserved exclusively for the Jerez product, and a body was set up by the Consejo in England to do this. But the second task was far more difficult, involving lengthy and detailed dealings and political lobbying with the European Commission to obtain regulations to remove the exceptions then permitted. And as Juan Luis has said, it was not until 1996 that we finally succeeded in getting the full protection without exceptions or derogations. And even then, it took several more years to ensure that the trade complied. But now we have succeeded. Brexit intervenes, leaving us uncertain about how, and indeed whether, the hard-won EU regulatory protection of 1996 will continue to be in force in the UK after 2019. But one thing remains clear, that the old 1967 Sherry judgment will continue to be an important part of the protection, as it will remain in force after Brexit, unchanged as a pillar of English common law upon which Sherry's protection in the UK stands. So our thanks to the Consejo for bringing the case, and now 50 years later, renewed thanks for this splendid celebration. Let me salute Sherry and the Sherry case, the Sherry houses, and the Consejo who brought it, and long may they flourish.
If anyone would like to take the floor and ask questions or comments to anything that has been said, please feel free to do so. I'm afraid I need a microphone in order to hear the lady. The question is inaudible from the interpreter's booth. I didn't hear the question. She didn't use a microphone. The situation in the UK, I believe, was the question. The producers of British sherry, are they? I think the question must have been something like, are the producers of British sherry still around? Or what happened to them after 1996 when they can no longer use the name British sherry? What did they do then? Well, if you'd like to add to this later on, you can. What they did was find another name that they could use legally. So I think in the UK, what has actually happened is they continue to sell quite a lot of products of this type. British fortified wine, I believe, is the name that they use in the UK. I don't know if either of the two representatives on the panel could verify this. These, of course, are very different from what is produced here in the sherry in the Jerez region. The characteristics of these products are, and this is probably my question that I would ask Juan Luis Breton. Could you describe what British sherry was at the time? What that were trying to compete with us in the 1960s on the British market? Well, the only experience I can share with you was as a newcomer to England, and I really didn't know much about British sherry when I landed there. All I knew is that if you wanted to go to a party, you had to take it was a good idea to take a bottle of sherry with you, but of course you tried to find the least expensive bottle of sherry or British sherry at the time. So that's all. It wasn't a matter really of how good it was, but how cheap it was. So I think that was the defining factor there, the defining feature. So we're talking about, the post-war years, and I don't really remember the brand names. Pelandes might be one. I don't know if you can help me here. Of some of the brands. There was Dry Sack, Harvey's Bristol Cream. No. Dry Sack was my bread and butter, he says. And then Bristol Cream, Harvey's Bristol Cream, because I was working for those two companies at the time. But at the time, the technique was to buy these bottles of British sherry And they really didn't taste that bad. Perhaps that's how poorly educated our palate was at the time. I have no idea, but for some reason, millions of bottles of this was consumed at the time. They couldn't have been that bad if so much of it was being consumed. But if you'd like to add something to that, feel free to do so.
Yes, can I clarify that answer? Yes. Yes, British fortified wine is what it's sold as, has been ever since for all this century since the judgment, the EU regulation was obtained. It is sold primarily on the brand names which existed prior to the change. It is a curious hybrid thing, what used to be called British sherry and British fortified wine. We have a product called British wine, which is neither British nor wine. It is produced from reconstituted, concentrated grape must, usually from Cyprus, but also from other wine-growing areas, where the grape must is dehydrated to about 20% of its original volume, and it is brought across to the UK in tankers and rehydrated with English water. I mean, the British part is just water. It is then fermented quite. And for some reason, the British Ministry of Agriculture has always maintained that the expression British wine is well understood by the consumer as being a term of art that is quite different from wine. It is the same linguistic absurdity that British sherry is not sherry, British wine is not wine, and they believe that the English consumer understands that. Lewis Carroll was also English.
We go back to those years. I was so unaware of what was going on, that we were drinking something that really needed one definition. A gentleman with a blender, because that's what happened. They blended, as you so rightly said, this must. They blended that with base alcohol, and they added sugar and yeast, and they blended it, and that's what you got. And what you got was British sherry. So it seems absolutely absurd that we were able to drink something of that nature, but we did. We drank it. And it seems unbelievable. We astonishingly did drink it, and millions of bottles of that were drunk. And of course, this was the gentleman's blender version of British wine, and that's what we knew at the time. A lot of associations are made that continue to work against the interests of a designation, a protected designation. With this, I would like to thank all of you for your attendance and for your contributions to today's discussions. Thank you very much.